Are you able to? Oh,
Oh, I think we're
we're
live.
live.
I
Hi,
think we're live.
guys.
Hey, hi.
I love
This
live. We had no
There we
idea.
go. This is Curt Verone,
And Brad Pinsky.
and we're here for another rousing edition of Fire Law Roundup for
Are you still there?
July 29th.
Ninth. Yes. Getting to the end.
July 29th of 2024, and I got that taken care of. Brad, go ahead. Let's get into this week.
All right. So I tend to see a theme. I don't know if these are like subconscious themes with you when you choose these, but I'm going to call my version of this disturbing. The whole, all five of these have some disturbing nature, some more than others. But with that, not to give anyone nightmares, but let's start with the least disturbing, I guess. But we're in Victoria, Texas, not Victoria, Canada. We're in Victoria, Texas, and there was an ambulance crash where the ambulance was, well, not allegedly, they were
It ended
indicted,
up
I guess.
submerged. That is what blew my mind. The ambulance is actually submerged in water. Thank God they didn't have a patient in the back.
Right. But we have a fatal, you're right. It was
Right.
fatal anyway, of course, but yeah, no patient. There was a settlement of $500,000, which is the maximum amount that under what's called the Tort Reform Act in Texas, they cap. I don't personally think that's fair. I don't think I'm not a fan of that. As somebody who does plaintiff's work, all the defendant lawyers are like, oh, great idea, except the ones who actually want to make money. But it's settled. And you can debate this any way you want. In any event, but there was also, and I don't know if you know the answer to this. The driver was indicted, right?
He wasn't
For
indicted. They submitted it to a grand jury and they returned a no true bill.
Oh,
But
interesting. So,
yeah,
okay,
but
so they avoided criminal liability
yeah.
and then got the civil settlement.
Yeah, and I think it's a warning. I would say maybe 8 to 12 times a year we see a firefighter charged with
Mm.
manslaughter,
Like in the, was
or
it Kentucky or
some
Kansas
sort of a
one?
homicide. Yeah, some sort of a homicide related offense. We went through Kansas City, just went through it, and particularly our younger drivers and the people who are supervising them really need to get them under control when it comes to speed. And there was some other maneuver which they said it was a faulty maneuver, so I don't know what the driver was trying to do, maybe pat whatever, but there was a couple of things involved speed, which was one of them. And when someone dies, vehicular homicide, negligent homicide, or the more serious manslaughter charge is
Yeah.
on the table. And it's not, I mean, it's not that it's rare, but it's happening enough that it needs to be a concern that we've got to have a conversation about.
And let me jump in. I think I left out a fact, which, right, there was no patient in back, but it collided with another vehicle, and then the ambulance goes in the water. So the vehicle it collided with was one of the people were killed. That's where the $500,000 comes from for the settlement. But look, I don't know what your view is, but to me, dash cams, and not just to have them to prove fault. What you need to do is you need to be, especially during the first 6 months that somebody's driving or something, you need to be viewing their driving through their eyes, the dash camera. And if you are, that could avoid a negligent supervision claim. You right. And it's a good policy we should be talking about on dash cameras, which we can address. But having the dash camera is good for determining who's at fault, but it's better for preventing fault. If you will review everybody's driving every so often, and you keep a log of it, and you said, we've viewed it, they're responding to this type of call, that type of call, and they're driving safely or they're not, you can avoid a negligent supervision and a negligent training claim, which is the reason that's important. So people know is many state statutes give you a qualified immunity for negligent driving. Not every state, certainly, but so even those, like in New York, you can only lose a lawsuit for reckless driving, a very tough standard to prove. But they also, a good attorney normally sues the department for negligent training and negligent supervision, which is almost never protected. It's a get around. So fine, driver, you're off the hook. Department, you're still on the hook because you let this driver who you should have known was a bad driver. And the question always is, Well, let me see your driver training forms. Let me see your supervision. And many departments have a driver. This is a plaintiff's trick, by the way. Many departments have a driver training form, but now it's been 5 years. And now the scumbag attorneys, I'm not one of them in this case, just in this case, but the scumbag attorneys can say, so department fire chief, you certified him 5 years ago, and since then, you have no supervision or training or other evaluation of his driving, and you never monitored it, blah, 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 right? And now it's like, okay, negligent supervision, you lose. And if you have a dash cam log, you could win. This will be, for those who have heard about Curt and our policy service, this will be one of the policies we put out to you about, how to prevent it. And driving's a huge area of liability. Right?
Absolutely. And, I go back to law enforcement and body cams. Police officers didn't want to see body cams, but number one, it prevents a fraudulent or false claim by someone alleging the officer did something wrong. But like you suggested, maybe the more important part of the body cam is from a supervision perspective, in that the supervisors can monitor the behavior of the officers, or at least check it. But here's the other thing. The officers self-monitor their behavior because they don't want to get caught.
They know they're being
And
watched.
It's the same thing with dash cams.
Yes.
And I remember myself. I mean, I started driving fire trucks when I turned 18, and when I got on Providence in 22, I mean, I'm still driving apparatus. I don't drive the way now that I used to drive when I was 22, and maybe I needed a little bit more supervision when I was younger. Not that I was a bad firefighter, bad driver, but the dash cams can provide that incentive to keep it under control.
In fact, it's funny, my dash cam in my chief's car, because when I became chief, I put a dash cam in every single vehicle, every truck, I would have put them on the bicycles if I could, right? But every time I get in the car, it went beep, 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 beep. And I'll always remember that. But every single time, like, oh yeah, I'm being watched. Right. And it's you might as well play a voice from the department that says, I'm watching you. And that's what I like. That's important for people to know they're being monitored. Unfortunately, with the dash cam or the body cams that we found, the police know they're being monitored. For some reason, the paramedics or firefighters stealing people's wallets never seem to realize they're being monitored.
Right.
So,
Right.
Okay. Anyway, that's it for that one. But yes, if you were in our must-have policy service, you would be receiving a policy that could save the life of people and save, department monies. Now we're in Ohio. This is the pinnacle of disturbing, and I'm not going to go too far into it unless you want me to, Curt, but here's what I do think. I think you can look at the law firm's website. I don't love this practice myself. I don't like to talk about cases in progress, and I certainly wouldn't do so, but they do, and they find it instructive or helpful, or who knows. I think it may taint a jury, but nonetheless, if you look, you're going to see what happened. But let me give an overview, and I'll get a little more specific. So we had an Ohio fire chief who's terminated and sues, right? Kind of step one. That suit is dismissed, but now he's facing criminal charges related to the same underlying allegations. I'm assuming his lawsuit said, hey, you had no reason to fire me. The reasons for firing him, however, are very clear in the criminal charges. And now there's a lawsuit against him as well. And it's by an employee who is known, this is all allegedly because it's from the lawsuit, as from a website, right? But I'm allegedly.
Well, we've got copies of the documents. So there's definitely the sexual harassment lawsuit by the female firefighter, a lawsuit by the chief because he felt like he was not properly given due process when he was initially put on leave and then later terminated. And now the second shoe or third shoe when this one drops with the criminal charges. He was indicted by a grand jury. And
now those mirror the sexual charges, because this is not harassment. He was, let's sum it up, groped her, grabbed her in some very private places, touched her, said something to her.
Those are the allegations anyway, very disturbing allegations.
Yeah, and when it's one thing saying something to somebody that probably doesn't get you arrested, but you put your hands on somebody, game over. Don't ever touch your employees, and don't even give them hugs unless you really know them, frankly. But touching your administrative employees, not like hugging somebody at a bad scene on a fireground or whatever. You touch, allegedly again, but you touch your employees, especially how he's alleged to have done so, and you may end up going to jail. And if what is true is said, my prediction is, unless he has a lot of money, I don't know how you get money from the fire chief's employer, because an intentional act of sexually assaulting your employees is not recoverable, because it's not within their job duties to molest somebody. On the other hand, if they knew or should have known, and the employer should have known, I don't know. This is going to be tough to recover.
It's a two-edged sword with the plaintiff's allegations here than what you're saying. I hadn't really thought about it like that, but they're going to argue that what he did was outrageous. It was criminal. Look at the horrible things he did. And the fire department's going to go, you're right.
We agree.
You're right. And guess what? That means we're not liable. You can go after him, but you can't come after us. So it's like a two-edged sword to the escalation that the plaintiff side in this case have sort of brought to the table. So crazy factual allegations. It's been now going on for over a year, and no end in sight, other than his suit is over. Her suit is still continuing.
Right.
And boy, just really an unfortunate situation.
Yeah, and I don't know if they'll get liability against him. I just don't know that they're going to get it against, and I don't know the law in Ohio. We could bring in Chip, I guess, but I just, if it's anything like many other states, I just don't see how you get the employer for the fire chief's outrageous intentional acts, which are not part of his job description. So. Okay, the next one I find disturbing because I disagree with it. I understand it, I just disagree with it. And here's the short part. I'll explain to everybody the legal rationale, but in short, a Louisiana court, and they're not a liberal court all the time, so especially the Fifth Circuit, but the Louisiana court has held that forcing a firefighter to clock in and out by use of their fingerprints is not an unreasonable search and seizure, because the act of fingerprinting, they go through two tasks, but they say there's no expectation of privacy in your fingerprints today. I fully disagree. And second, they say that it's a legitimate business reason. They go through two different tests, but it's a legitimate business need for the fingerprinting. I also disagree with. There are other ways to do clock in and clock outs rather than using fingerprinting. They have facial scans. They have all sorts of things you could do now, or actually signing in or using a key fob or something. There are other ways, and key fobs are just as good as fingerprinting, right? As far as I'm concerned. I want to caution everybody. For example, New York State, I don't know what other states, but New York State has a law that says use of mandatory use of biometric fingerprinting is illegal in the state. An employer may not use fingerprinting as a requirement for any benefit, which is interesting because many departments, fire departments in New York State, for our New York State listeners, they use a couple of different software programs. I won't mention them, but they call it fingering in and fingering out. And, a call goes in and or a meeting happens and they leave it open for a couple of minutes so people can finger in. Well, they use that to give out length of service award program, pension benefits to volunteers. And I argue that violates the state law because that's the only way they're giving them to prove points to get it. And I think it's legal, but it's not unconstitutional, says this court.
Yeah, I agree with the court, Brad, really. And I know one of the first things, our first day on the department, we were fingerprinted on Providence anyway. And I think a lot of departments are. And personally, I don't have a problem with that, given the expectations of, like, we're not librarians, okay? We're going into people's homes when the people are not there. There's a lot of reasons why I think it makes sense. And I think today, back in, I started in 1979, DNA testing was not what it is. but I know the military today, for good reason, does DNA testing so that, if the unfortunate happens, you're going to be able to identify someone's remains or partial remains and different things. So, I think in terms of the biometrics, I mean, New York is what it is. You guys have your laws, but personally, I don't see a problem with this. I think it's in the mainstream. I haven't researched it, but I think strip everything else away, the court applied rational basis review. They didn't apply strict scrutiny, and just said, hey, it's a reasonable solution. Maybe not the one we would have chosen, but it's a reasonable solution. So certainly in a state like New York, maybe California, it'd go a different way.
The liberal states. And look, I don't have a problem for fingerprinting generally when it's used for like a DCJS or a federal background check or something like that. The problem I have here is you're requiring someone to fingerprint in to prove they're there. Now, the problem is
I think that's unnecessary, personally. Okay, but setting that aside, the legality of it is a separate. I think it's ridiculous. Okay.
And if you use the lowest standard, they don't ask the question, is there another less intrusive way? When we get to the higher standards, then they would, if the court chose a higher constitutional burden of proof, right, like a strict scrutiny or something, they would have said, is there a more reasonable, less intrusive method they could have used? And they could have seen, and there would have been, right? But they by choosing this, I'm going to suggest that the court's going to be upheld because all they did is follow other court decisions. Had I not known they would have followed other court decisions, I would have said, they're going to lose. But in any event, so that's what it is. And just like many other states now, there's a lot of court decisions that says you can use fingerprinting for even less important tasks, such as clocking in and clocking out.
Yeah. And I don't know if I know you travel quite a bit. I travel quite a bit. I have Clear, and, Clear uses biometrics. You can either fingerprint in or use the eye, the retinal scan, whatever it is.
Yep.
And, but I mean, is that really necessary? I think, I mean, I don't know what their issues were down there, whether they were having problems with substitutions or whatever it may be, but there's easier ways.
A key fob is an easy way, and I only have my own key fob, just like I have my own fingerprint. So
you can basically keep time by what do you call it? By the exception, they call it. You track time by the exception. And what that means is you are on A shift, I'm on B shift, somebody else is on C shift. Unless you are on vacation, sick, or some other leave,
you're there,
expected to be there. And so all you have to do then is track the exceptions.
Yeah.
And that's the easiest way to do it. But there may be reasons why this department felt like they needed to get. And I've been contacted by numerous city officials about, hey, we want to track the substitution and all that. I'm like, why?
Yeah.
Why you're going to create a headache for yourself. But
if you allow it, right, then I agree. Why do that? I think, when I was chief, I had problems with people staying late. And I said, listen, I'm good with you staying late, but I want you clocking out, or at least recording your out time. We had the lieutenants do it.
That's a good point, where people aren't on shifts. That's a good point.
Right. And if they're just hanging out to do their laundry or whatever, but I said, you cannot do any duties of firefighting after you're done. And, and so many people said, listen, I'm just finishing up the laundry for the bunk room, whatever, it'll take me another 10 minutes. I'm like, no, you're done. Hand it off, go home. You're not staying. And I think people are too lax with that as employers.
Yeah, no, for sure.
Okay, let's go to Oregon because they have great Pinot Noir, but for any other reason, let's go to Oregon, the Ducks, I think. And a jury has awarded over $200,000 to a lieutenant. And again, this is also disturbing because he's a disabled veteran. I mean, this is a short and easy thing. He raises concerns about and he does it as a whistleblower. He raises concerns that a civil service appointment list is not crediting the points basically or properly because he's a disabled veteran. He should get extra points. Everyone agrees with him. And yet they then don't promote him because at least the jury found because he was a whistleblower, even though he was right. And nobody seemed to have an issue that he was it didn't seem like they were mad, but somehow the proof came out and the jury found that he, was retaliated against for making this report. I had a conversation with somebody the other day and I said this: I can't prove your discrimination claim, but I can prove your retaliation claim. And it's much easier to win a retaliation claim than a discrimination claim. And here, right, they won the retaliation claim. The retaliation claim is won because all you have got to do is say, I reported something and you retaliated against me as a result. And here's my email when I did it. And then, within a month of that, something bad happens to me. Well, go figure, right? I have a client now, I won't say it, but the next day after a report was made, something bad happened. And I'm like, a jury's going to be asked, you're good for all these years, and one day after you make this report, something bad happens to you. Retaliation is much easier to prove, and that's really my point to everybody. Don't retaliate against anybody if they've made a report or whatever. If you say, I'm going to get them, you know what's going to happen? You're going to do something, and then somebody's going to come back and get you. Just don't retaliate, ever.
Yeah, and I think like this case, if you go back to the earlier discussion that we had about this, let me see when it was. It was a couple of years ago, 2022, Brad. I think we talked about this. Yeah, and he was having some sort of, I'm assuming PTSD related, because he's tracing it back to his work for the military, and apparently there was some concern, the department had some concern about the way he was behaving, and they told him, you need to remove yourself from the list. You're next up for promotion to captain. You need to remove yourself or we're going to remove you. And if you force us to remove you, you'll never be able to promote again. Right. I don't know if that's, I'm assuming that's a threat, but I'm not sure if it's in their system or if it's just their, an idle threat. They don't really have the ability to do that. In either event, that would be enough for retaliation. And maybe they were trying to make the right decision, whatever, but it certainly has all the appearance of retaliation. It looks like that's what the jury said happened factually. So.
And let me give some advice to people, because I think people are so afraid of in writing, right? If I had a legitimate concern, so day one, the guy, relates a concern and we're like, we agree with you, we were wrong, whatever. And day two, something else happens and you're going to, this is probably from your toxic employee lectures, but so day two, something happens because this person does something that truly warrants discipline or some corrective action. I would be starting my letter with, this happened yesterday, right? This is what you do. This is what we're responding to. And we acknowledge, I would put right in writing, we acknowledge that you filed this claim here, and this has no relation to it whatsoever, right? We are not retaliating against you because of it. Now, that's just words on paper, but words on paper matter, because if you don't acknowledge the appearance of retaliation, the jury's going to acknowledge it for you. And you might as well bring it right to light, saying you did something right after you reported something. And my question to you, Curt, is, because I do you see people who are, they're like, aha, I got you. I reported something and now I can act any way I want because I'm clear, you can't touch me.
Yeah, and we're not very good at documenting, and we're not saying this particular firefighter certainly fits into that sort of moniker of a toxic employee, but one of the problems that we have is we're not good at documenting the behavioral component. We're certainly good at saying you're rude, you're disrespectful, you speak out of turn, those types of things, but we're not very good at documenting the factual rule violations so that at the end of the day, it looks like we're picking on someone. And the reality is the person is grading on everyone around them, but we just haven't documented that well. And we end up with these conclusory types of statements that, they don't hold water. So you've got to get factual, when the person is actually engaged in that kind of behavior. And then even better, get them to acknowledge, yeah, I did do that particular thing.
Right. And I'll tell you, one thing to be careful of is just occurring to me, because I'm now kind of replaying fact situations I've had on both sides of the trial. what happens is, okay, so they don't trace anybody. They're so bad at documenting counseling sessions and discipline other than serious discipline because they were close, small department. And then this person does something, right? And now you're like, okay, I'm going to start writing everything you've done. Now, the fact that you're writing everything they've done, fine, they did it, they can be disciplined for it. That's not retaliatory. But the fact that you've changed your practice to start documenting everything, even though there are legitimate concerns, that could be retaliatory. So you should be documenting counseling, discipline, right? As Curt's saying, for everybody, so that when their issue does arise and you need to go back and say, you've been a problemed employee for many years before this, you're not... They're not saying, oh, I have no disciplinary history in my personnel file. And
it can't be the only person in the organization that has ever had this kind of a write-up done for them, because then that kind of speaks of singling the person out, selective enforcement, and so on. Yeah.
Yeah. And so somebody asked me when I was fire chief, and Curt, you even, I think, said it once, is how come you guys think of this stuff? Well, we think of it because we've experienced the good and bad of it constantly with trial. It's like saying, how come you fought a fire the way you did? Because you've seen that fire before. You've seen that building on fire before. You've seen that type of car accident before, right? So for lawyers, same thing. We've seen all the things that go wrong when somebody didn't do something, and that's what we try to point out to you.
Yeah.
Okay, last one. This would never happen. I'd like to say this would never happen in New York, except this is from New York. This is an hour south of me in Binghamton. And what the part I was going to say would never happen is somebody goes to jail, because in New York State, unless you murder 5 people, you don't go to jail. I mean, it is very tough to go to jail. So here, and I'm not even trying to be facetious. It is very tough to get sent to prison, and we have no bail, right? So you're out the next day in any event. And the exception for this is violent crimes. So here, arson can be a violent crime, certainly. We have, and the facts are simple. We have a woman who's accused of arson, spends 14 months in prison awaiting a trial, ultimately acquitted by a jury. Now, without more, that doesn't entitle her to anything. However, the department alleged, well, I mean, she's acquitted, right? So she's sued. So allegedly, but I'm almost presuming this to be true. They didn't know the cause of the fire. It was under investigation. At the time they have an arrest warrant or charges brought against her criminally, they allegedly don't know the cause of the fire. So they're a little premature in accusing her. And then apparently they knew that it wasn't arson for a while, I guess. And all this time she's sitting in prison for 14 months. That's the part I'm shocked about, because normally, unless somebody died in the fire, they're not sending you to jail for this. And she sues them for false imprisonment. If they truly did know that they didn't know the cause of the fire, or they didn't have enough proof for her, how the heck do we get an indictment? I mean, I don't understand any of this, frankly. But
I think this case, as soon as I read it, takes me back to cases that I was seeing a few years ago that actually go back to cases in the 70s and 80s and a little bit into the 90s, when arson convictions were being successfully prosecuted using junk science. And the alligatoring is clearly a sign of arson, and crazed glass is a sign of arson, and all that junk science, which is absolutely no proof behind. There's no scientific connection between, behind that.
Right.
And we've got a ton of those. I've got probably about 25 lawsuits, most of them by people who were convicted, coming back and suing the prosecutors and the arson investigators and police officers. But this one is a little bit unusual in that it's someone who was accused and they won at trial, and now is raising the malicious prosecution and abuse of process, etc.
Yeah, and just so people know, just because you're acquitted by a jury, that doesn't get you a wrongful prosecution. It's a mandatory step for malicious prosecution. Can't win without it. But just because you win at in your criminal trial doesn't get you anything. But when you have a false arrest type premise, or you should have known better that there's no proof against me, that's different. I do want to bring this full circle as we get to the end. if you look, the complaint alleges 9 different causes of action. Number 7 is negligent hiring, training, and retention. Go back to my dash cam comments. This is kind of where that comes from. It is going to be much harder for them to prove a false arrest or malicious prosecution, et cetera. But negligent training, right? If they say, well, had you trained them on it, this never would have happened. That always comes back to haunt you. So I go back to my, loop this to the beginning where I say, use dash cams and monitor the dash cams. Here it's the same thing. Was somebody monitoring this case? Was somebody overseeing the indictment and, putting this woman in prison? I don't know, but she's going to be paid money. I imagine I can't believe this is going to settle.
Just ran the numbers real quick. And I've got 58 cases.
Wow.
Yeah,
wow.
Malicious prosecution or wrongful conviction cases.
In an arson case or generally?
Yeah, arson.
Oh, Jesus. Okay. So look, and I'm not an arson investigator. I took principles and that's all I know, but I do know like Chip Comstock, a good friend, does a lot of that case, but arson is hard enough to win, right? But this is just, you got to have the facts to win an arson case. I mean, dead on facts. But to not
should theoretically, but sometimes our criminal justice system doesn't work as well as we think it should.
Yeah, and in this case, I think it failed her. I don't understand why, if true, the prosecutor didn't say, what proof do we have, or who knows, maybe they bamboozled the prosecutor. I don't know, but I feel badly for this woman if her allegations are true, that's where we are for the week.
All right. Well, that's going to do it for another edition of Fire Law Roundup. Please click like and share. We could really use the support on YouTube. We really benefit from that. And it improves our algorithms, gets us out there a little bit more. And we'll see you again next week for the next.
Find us at musthavepolicies.com if you want to look at our service.
Absolutely.